Hey everybody, it's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. And today I'm going to talk to you about the beneficial interest clause in a will. I think it's also called the spendthrift clause in a trust. Depends on what document you're looking at, but if you see either of those things, I think they're the same. I only have the will one pulled up in front of me, but I'm pretty sure they're the same. But if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can go to cmslawfirm.com. Okay, what is the beneficial interest clause in a will? I was doing a will signing today, and for the client wanted to go through the sections section by section, which is fine. Try to do that before they come in to sign, but that's okay. We're full service, so we do whatever we need to do. And we were going through this, and it's really the beneficial interest clause is something that gets asked like almost every time. So I thought I would make a video about it and talk about it. So if you saw that pop up in your documents, or you were wondering if this is possible, maybe you are an heir and you've seen the will and you know you're about to get something, then I have bad news for you, because the beneficial interest clause prevents you from being able to have any fun. All right. This is what the beneficial interest clause says. I'm going to read it. It says, the interest of any beneficiary in any share or part of this will, both as to principal and income, shall not be alienable, assignable, attachable, transferable, nor paid by way of anticipation, nor in compliance with any order, assignment, or covenant, and shall not be applied to or held liable for any of their debts or obligations, either in law or equity, and shall not in any event pass to his, her, or their assignee under any instrument or under any insolvency or bankruptcy law, and shall not be subject to the interference of or control of creditors, spouses, or others. Boom! Beneficial clause. Beneficial interest clause. I love it. Now, what does this basically say? This basically says, if you are an heir under this will that I just read from, then, and you find out you are going to receive an inheritance. Let's say you know you're going to get $1 million. It literally says, Christopher Small is going to get $1 million when I die. You'd probably be feeling pretty good about that. Now, let's say you knew the person, you didn't know. You had an idea that the person was not going to die for a very long time, and you didn't want to wait for that share to come to you after death. You wanted to try to get a little something beforehand. What you could do, potentially, is go to someone, usually a ruffian, a scoundrel, and you could say, hey, I am in line to get this $1 million bequest. See, you show them the will. And what you'll say is, I am willing to share. I'm willing to sell this $1 million interest to you right now on the spot today for only $250,000 cash. And so what you're saying is, you give me $250K today, I will assign my interest in this $1 million gift sometime in the future to you. Now, if this person dies in like a week, that person made off really well, right? There's $750K plus. If they have to wait 25 years, the value may be a little bit less high than it would be otherwise. But you, as the heir, can get some money now. The beneficial interest clause says that's not allowed. It also says, let's say you have a business and you go bankrupt. The bankruptcy court cannot say, we are going to attach your $1 million inheritance in the future to this bankruptcy proceeding. Not allowed to do that. Let's say you get divorced. Can't do that. Okay. Let's say your spouse runs up the bill. Can't do that. So what this basically says is, no matter what crazy scheme or idea you come up with, you cannot get your inheritance until it's time to get your inheritance. You got to wait. If you make a deal with somebody, that deal is not going to hold up in a court of law. It's not going to be a valid agreement. And if you show the will to someone and they read this beneficial interest clause, then they are not going to make a deal with you, because they know that the deal is going to be voided in the future whenever it comes to pass. Okay, so that is the beneficial interest clause. Kind of interesting. And it's one clients always see that they're curious about. I think just because of the nature of the language, but that's what it means, right? So hopefully this made sense. If it did, hit the like button, leave a comment, leave a question, follow me. If you have other questions, let me know. And if you want to talk about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. All right, that is it for today. As always, I am Christopher Small. I am the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again soon. See ya.